annoyed Perth and Gross Council, and you annoyed Police Scotland.
I really
and you annoyed your daughter, and that seemed to be one person too many. So we've got here next on the list, we've got 28th of August, it didn't hang around, a letter from Lynn Clark, solicitor, Perth and Ross Council, to your solicitor. Following receipt of serious allegations made against your client. Serious is pushing it.
Yeah.
In relation to the care of his son, John William Shields Jr., Perth and Ross Council raised an action for removal order under Section 14 of the Adult Support and Protection Act 2007 at Perth Sheriff Court on Monday the 25th of August. So this is them admitting on the 28th that they'd been to court, right? An application was considered by Sheriff Fowlis in chambers and refused. At the present time, Perth and Ross have not raised any further legal proceedings in relation to your role as guardian. So, your role as guardian at this point is unaffected. The only thing that has allowed them to seize your son is the bail conditions. There is nothing else.
There was no order. There
was no order, right? So that is absolutely crystal clear. They said, we're actively considering our position, and should you decide to raise proceedings, should we decide to raise proceedings, we'll ensure any proceedings are sent direct to you as well as your client. Now, the charges. Let's come to the charges. Because, you see, John, there is actually a documentary record of life in your home, because it was run as a business.
Yeah.
We've checked the record. So, the charges are that you assaulted your son on 3 separate occasions. On the 25th of July, the 4th of August, and the 22nd of August 2014. All these assaults were witnessed by carers Debbie and Ashley. So the following is a complete list of the daily logs from those days. 25th of July, John Jr. was on holiday at a caravan park with his carers. They reported. 25th, 7:14. John awoke 7:15, meds given, up at 9 o'clock, breakfast given, washed, dressed, teeth done, music on, listening through headphones. Walked down to shop for papers, dinner in caravan. All packed up to go home, left at 4:30 to drive to Perth, had tea at Morrison's. Back home, bags unpacked.
That was it.
No assault. No, not even a hint.
What happened?
Nothing.
No.
Okay. Well, next one. 4th of 8th, 14. Right. John picked up in Perth today from Debbie and Ashley. Went to Morrison's for dinner. Drive home, bag unpacked, in bedroom watching challenge, into kitchen for a cup of tea, tea in bedroom watching news. Trainers on, out for a walk, 1 hour 15 minutes. Home, bathed, pyjamas on, meds giving, no issues. Not only, hang on a minute, hold on a minute, not only did they not record an assault, not only did they not put in something that might suggest something was off without it being obvious so that the gruff big John Shields wouldn't beat them to a pulp, they voluntarily recorded no issues.
Yeah.
That's the record. Anyway, we've got a third one. Maybe we'll do better. 22/8/14. John awake on arrival, meds given, up at 9 o'clock, into bathroom, washed and dressed, ate cereal in kitchen, tea and toast in sitting room, with dad watching TV. Bedroom, hoovered and dusted, bedding changed, John in bedroom watching Fools and Horses, into kitchen for dinner, then back into bedroom. John shaved, bag packed as going to mum's for weekend. Dropped off in Perth from Debbie and Ashley. No assault.
No.
Right? So it is troubling, to say the least, that not only did they not take any of the means of alerting people to abuse, if abuse was going on, but they actually recorded, specifically on the days where they said, where the alleged assaults happened, no issues. I find the fact that that did not get noticed by any part of our criminal justice system disturbing. We've now got the SWIFT system. The 2nd of September 2014. So this is after you've been charged, arrested, charged, all of this. There's an entry made in the SWIFT system, the computer system that records everything for Perth and Ross Council Social Work Department, presumably SWIFT, the SW's social work, as part of investigation and risk assessment for protection of adults at risk. So, one point here, they're putting the paperwork in place after you've been charged. Right? There is no paperwork on anything against you up until this point, 2nd of September 2014. Yeah. The system doesn't show anything against you until after you've been charged. But the allegations talk about perpetual abuse, constant abuse.
Yeah.
This seems unbelievable.
But
anyway.
When you look at the SWIFT and who done the SWIFT reports, this is the same social worker that we didn't want in the house.
Yeah.
She actually took the SWIFT investigation on. If I remember right, in one of the court proceedings that followed that, they questioned her involvement because there was like 3 or 4 different areas of investigation that her name was next to.
Oh yeah, Gillian Morrison. Gillian Morrison was the council officer for learning disabilities. Gillian Morrison was also the key worker.
That's right.
Gillian Morrison was also the main assessor.
Yeah.
Right? Gillian Morrison had many, many jobs in regards to the SWIFT system.
Can I say one other thing? Like,
Please.
as a guardian, you're meant to be interviewed, questioned, because there's rules and regulations that the guardianship covers what keep me safe. Now this Gillian Morrison, she never took part in any of them. She never interviewed me, she never came near me. But here she is making a SWIFT report and all the allegations that's put forward to her, and she still never ever come near me.
So, I mean, some of this is just repeating the allegations,
Again,
which we don't need to go over too many times because I've still got 2 versions of this to recount because we haven't got to the main 2 police records yet. So we have the 2nd of September 2014 SWIFT record, presenting concern. So this is, how did it all start? On Friday the 22nd of August. So this is over a weekend, so it's less than a week from first concern to you're arrested, charged, and your son's abducted. Less than a week.
Yeah.
Right? That's how fast it was. After 12 years of glowing reports about you as a father, we've got 6 days. That's moving some. Presenting concern on 22nd of August, Friday 22nd of August, Jennifer Shields, John Jr.'s sister, contacted Perth and Ross Council out of our service and raised concern that her brother was allegedly physically assaulted by his father. When it is alleged that on the 4th of August, Mr. Shields Sr. forced his head back, brushed his teeth, and stated that there was nothing wrong with his effing teeth. This information was divulged to her via a personal assistant who supports her brother. So this is describing the correct method of brushing the teeth of someone in that condition without the swearing. So it then says, Learning Disability Social Work Team followed up the allegations on Monday the 25th. Dates of alleged incidents were confirmed by Debbie as the 25th of July. Alleged incident having returned from holiday in Seaton Sands. This is a patting of the stomach issue. She, Jennifer, confirmed the incident of 4th of August. In addition, she advised of another alleged incident on the 22nd of August. So 2 of the 3 came directly from your daughter.
Yeah, well, my daughter seems to be heavily involved in the setting me up. See, before this all happened, my daughter had approached me and wanted me to put my ex-wife on joint guardianship, to become joint guardianship. And I says, why? So she gave me a story about the ex-wife being struggling, got some sort of bone disease, needed money, and being guardianship would entitle her to half the monies that goes with looking after John. And I'd actually say to my daughter, no, can't work. I says, she lives in Glasgow, we stay in Blairgowrie. John's life is Blairgowrie, isn't it Glasgow? You only get him a couple of days a month, every 3 weeks. I say, so it's just a scheme that cannot work. From then, I knew my daughter's going to cause me problems.
Yeah.
But
the money's for John.
Yeah, it's his thing. But the thing was, like, I didn't know at that time that my daughter was so involved with these carers. She was meeting them on the Friday, and it was another carer actually warned me, and I never took her warning on. Her name was Jackie, and she was warning me all the time that something was going on. And I just couldn't believe my daughter was doing this. I just could not believe that she was putting in place this setup. And I can remember Jackie coming in and she says, John, there's something wrong here. She says, I was picked up with my husband up at the Broxton roundabout, and we just so happened to be sitting in the car park, and who comes out? Debbie, Ashley, Jennifer Shields, John Shields. And she says, I discovered this was going on in most of the visits that they made up to pick John up. But I never thought this was getting, I thought it was just a case of, the carers' jobs were take John to Broxton roundabout, hand him over to the daughter or whether it was the ex-wife and go away, and that was it, and they had to leave. But they weren't. Jackie told me they went in and they sat inside like a McDonald's or whatever is it's up there, and she says they were there for a good half hour, an hour, and she says, and it was just heavy conversation. And she, you know, I take my hat off, this, she told me this, but I didn't listen to her. I didn't think my daughter could even think to do what she's done, as I said. And come the 22nd, there'd already been a phone call that afternoon at 3 o'clock by my ex-wife. The two carers had delivered John to Broxton roundabout, gave him over to my ex-wife and my daughter, and headed down to Glasgow with him. And by the time my ex-wife got home, she's on the blower to Perth and Gannos Council, complaining about what these allegations that were coming through, these carers. And I still never knew anything was happening. I says, and then later on that evening, my daughter then decides to phone the hotline and puts in the same complaints that my ex-wife had done to make it more serious, that she'd learned about it, but she was using her position.
Yeah, because she's a
clinical psychologist, doctor. She's using that position to put forward what her feelings were. So that was like 22nd she's complaining. Oh, the 22nd, actually, it came out that my daughter had actually put a complaint into Perth and Gannos Council on the 21st. And guess who the social worker that she was talking to? Gillian Morrison. Again, she comes up. It was her again.
Okay, so we've got the record, in the SWIFT system, we've got the record of investigation, such as it is. So they say John Jr. is supported totally by his immediate family and paid carers. Those mentioned support John Jr. in all aspects of his daily life. He requires support 24/7 all of his life. John Jr.'s main carer, his father, has been offered a care assessment in the past but declined. I think that's a smear, but it's a small one.
Yeah.
Other agencies that support John Jr. include Broxton Dental Surgery, Ardblair Medical Practice for general health needs. Mr. Shields has links with Speen, Palmas, Dundee, and is liaised with various consultants in relation to specific diagnosis. Doesn't sound like neglect, John.
No, it doesn't.
John Jr. has limited communication and uses gestures and noises to indicate informed choice and pleasure and displeasure. Due to communication difficulties, he was unable to contribute to the investigation. Therefore, information gathered in respect to the allegations was obtained from other parties that didn't include you or Janice. Following initial allegations, concerns were raised in relation to John Jr.'s safety and well-being whilst in the care of his father. An application was made on the 25th to Perth Sheriff Court for removal order. However, based I love this has been one of the things I've learned is weasel words. This has been a masterclass in weasel words, right? It try and suggest something without saying it because it's a complete fabrication. That thing that comes up all the time. It came up in North Lanarkshire. This is a Perth and Kinross Council example. So they're talking about they went to the court to say we want a removal order, and the judge said no, get lost. So this is how they describe it. They went for a removal order to be granted for John Jr. to be placed into the care of his mother, Mrs. McJimsey. However, based on the circumstances at that time and evidence, it was deemed by the sheriff that John Jr. did not meet the criteria of being at risk of serious harm. Really? That's in there. So that's the Monday.
Yeah.
Based on the circumstances at that time, that's padding. Right? That's to suggest something had changed by Thursday. Nothing had changed by Thursday. Yeah. It was the same allegations, it was the same information, it was the same police statements, it was the same everything.
But remember, we've managed to get together documentation of what happened in these statements. When you look at the documentation that we have now, we never had it then. We got the police statements of the interviews that they took with Debbie and Ashley. When you look how desperate Police Scotland were to get some, now the allegations had been put through on Friday the 22nd from my ex-wife and my daughter. By Sunday night, we had Police Scotland going out to a carer's home at 11 o'clock at night, take a statement off of her. And then we discover on the Monday morning, my daughter is phoning Perth and Kinross Council. This is coming through paperwork that we got for Perth and Kinross Council. My daughter is contacting Perth and Kinross Council on the Monday morning asking, what's happening here? What's happening with John? What we have discovered is the social work department that morning, and this is Gillian Morrison again, was meant to be coming out to speak to me as a guardian. They were meant to come and interview me and let me know what the allegations was. And somewhere along the line, this got stopped. And then they decided, let's go to court that afternoon where the judge threw it out. Now the judge has looked at this and he's went like that, there's nothing here.
So we've got here, this is again from the SWIFT system. It said, the next bit is very interesting. Through joint Police Scotland and social work investigation. Now, our position has always been this is a multi-agency conspiracy.
Yeah.
Right? To get you done. That confirms it. Through joint Police Scotland and social work investigation. These two organisations are working hand in hand. Right? There's no checks and balances, there's no separate organisation, they're working jointly. That says, yes, there was a conspiracy. Right? To do good or to do ill, people will judge themselves. But that confirms that it was a conspiracy. Through joint Police Scotland and social work investigation, Mr. Shields Sr. was interviewed and subsequently charged with 3 counts of physical assault against his son. As a consequence of the charges, police bail conditions were imposed on Mr. Shields that precluded him from having any contact or attempting to make contact with his son. At this time, Mr. Shields agreed for his son to be placed in the care of his mother, and John Jr. was subsequently conveyed to his mother's home in Glasgow. That is, of course, a lie.
A lie, yeah, total
yes.
lie.
So they're recording false information on the SWIFT system, and their explanation is you consented.
Yeah, which would never happen.
Which it didn't happen. Okay. As a result of social work investigation and multi-agency decision, multi-agency conspiracy, Perth and Kinross Council launched an application in terms of Section 71 of the Adults with Incapacity Scotland Act to have the Chief Social Work Officer replace Mr. Shields as welfare guardian on an interim basis. Right? The Section 3 directions were granted on an interim basis on the 12th of the 9th, 14. So they've put in an interim guardian, which is the Chief Social Work Officer. Following that decision, Mr. Shields Sr. was informed that John Jr. would continue to remain in the care of his mother. Mr. Shields Sr. appeared at Perthshire Court on the 16th of September to answer the charges made against him by Police Scotland. He pled not guilty. Mrs. McJimsey and Jennifer Shields said that their wish for John Jr. was to remain in their care on a long-term basis and have submitted their own application for welfare guardianship. The proof of this is to be held on the 19th of February 2015. Family views. They record the family views. Mr. Shields Sr. is the alleged perpetrator and is subject to a police investigation, has been charged in relation with 3 minor assaults, and there's an ongoing investigation into welfare neglect. I think if they hadn't pinned the assaults on you, they were going after the guardianship with neglect. I think that was the backup plan.
The strange thing about that neglect charge, that was something they never ever talked to me about.
It went away.
It disappeared.
Yeah. It just died. Due to this ongoing investigation, the social work department has not spoken directly with Mr. Shields regarding the allegations.
Nope, never.
So their full and thorough investigation into John did not involve at any point speaking to John or his wife Janice, or it would appear any of the numerous social workers that you'd worked with who spoke so glowingly of your relationship with your son.
Yeah.
Okay. Mrs. McJimsey believes that following the allegations, her son has not been looked after by her father and would like John Jr. to remain living with her in the long term, so she now wants the guardianship, which she'd asked you for before because she wanted money and she was struggling. So now we come to Jennifer. The records of family views with her says Jennifer Shields is concerned for the welfare of her brother and does not feel her father is the right person to be taking care of him. It says for him, but of him. So that's standard, that's her professional qualification speaking. Yeah. She knows what to say. But the next bit's very strange. It says, she stated clearly that she believes that her father is abusing his powers as a welfare guardian and is using his powers to punish others and not using his powers in the best interests of John Jr. Now, she came to you and asked for joint guardianship so her mother could get money. Mm-hmm. And you said, no, it's all about John. So she's now saying, well, he's using his powers to punish others. She's saying it's all about her. And she's saying that when you said, no, you're going to be administering the guardianship in interests of John and not in the interests of your ex-wife, that was somehow a problem. She's essentially accusing you of the very opposite of what you did. A very strange statement. So we've then got... We've got the risk assessment. I'll just very quickly highlight a few pieces from this. It's awful. So risk identified. John Jr. is at potential risk of physical harm from Mr. Shields. Right? And then they say triggers. Triggers are not known at this time. However, based on witness reports, it appears that the risk of harm when Mr. Shields Sr. becomes angry occurs as a result of John Jr. being non-compliant, or there's a question made in relation to Mr. Shields Sr.'s ability to care for his son. Now, that's weird, because they're saying you're a threat to your son. They're saying the trigger for that is when your son becomes difficult, right? I don't believe that. I think from everything I've seen and talked to you, I think that you were probably extremely well placed to deal with the difficulties of caring for your son. But that at least is an allegation that has some rationality about it. I mean, it could be, right? Someone in that position could become overwhelmed and become irritable. It's at least got something about it. Or there is a question made in relation to Mr. Shields Sr.'s ability to care for his son. That can be nothing to... John Jr. is not going to go, well, actually, Father, I think I would question your ability to care for me. That doesn't come from John Jr. No. That can only come from your daughter or your ex-wife. What's it doing there? It's nothing to do with the risk to John. it's put in there because someone is typing out what someone else has written and they've not thought about it. They then go in and say, following Mr. Shields Sr. being charged with minor assault against John Jr., bail conditions were put in place stating that Mr. Shields Sr. could not have contact with John Jr. This meant that John Jr. was unable to remain in the house with Mr. Shields Sr. Right? So that's an admission that the bail conditions resulted in the abduction. Right?
Yeah.
That's completely confirming that. And just to say it one more time, when you signed the bail conditions, did anyone point out that they were going to use this to remove your son?
No.
Right. Okay. Right. He was. This bit will upset some of the people watching in the sides here. He was supported by social work staff to travel to Glasgow to stay with his mother. Supported by, that's another wonderful use of the English language. Abducted, right? Using trickery and deception. So it's how they want to be seen. At present, John Jr. is not being cared for by his father and therefore is not at any further risk. Potential consequences, John Jr. is not able to have a relationship with his father. Yes. So it goes on. We've got bits on the neglect, which kind of died a death. It was alleged that John Jr. is the subject of neglect to do with heating in his room, food from the reduced counter. That's not neglect. Not having received dental treatment in due time, that's just not true. The treadmill being set at a level too high, which is again this nonsense from the carers. It's all going in there. There's no editorial control. There's no checking of whether the records are in fact in any way accurate or reasonable or sensible. It all goes in. Oh, someone's made an allegation. In it goes. It doesn't matter if it's the wrong place. It doesn't matter if the allegation makes no sense. It doesn't matter if the allegation is completely contrary to everything they've recorded everywhere else. In it goes. There is no point at which these are assessed for accuracy. This is one of the fundamental failings with the system. Rubbish in, rubbish out.
Well, you've got to recognise here, you've got authorities that are just working on their own. They're rogue. They're doing whatever they want. Well, you've got to go back to all these allegations, all this stuff that you're reading out of here. Never once, as a guardian, was I told, challenged, asked about. You know, this is it. The neglect of what a guardian is. The local authorities are destroying it. They are ruining. If this is what they do to people who are trying to look after their sons and daughters who have got severe learning disability and you've got to take a guardianship up, if this is the way the local authority treat you, get rid of it. It's just not on. It can't work.
Yeah, the local authority, the operating in this manner, the local authority couldn't be trusted for anything.
They can't be trusted, no.
So they've got analysis and recommendations. Mr. Shields alleged to have assaulted his son on 3 occasions. There's an ongoing police investigation into a potential charge of neglect. I don't think that ever was an ongoing police investigation into that.
No, it's never been. We've actually asked about it, but
just,
they don't answer.
It just died because there was just nothing. These allegations were made by Jennifer Shields,
again,
John Jr.'s sister. It's her. She's everywhere on this. Who had received information from 2 of John Jr.'s PAs. Mr. Shields Sr. is due to appear in court, etc. So they made some further inquiries. They didn't just take the gossip. They went to the GP. Dr. Boost, GP, advised on the 25th of the 8th that John Jr. had some minor ailments such as a cough and a sore leg, but nothing major, in the past few years. He'd been seen by the nurse on the 25th of March for his weight check. His weight remains a concern for his health. His last appointment with the doctor was in April 2013, so it'd been more than a year since he had to see the doc. There was no information recorded relating to dietary advice provided, although there was a recommendation for John to exercise more. So the GP was not a problem, doesn't see anything. So Broxton Dental Centre also, in a letter of the 17th September, confirmed that John had attended for an emergency appointment with his father on Tuesday the 5th of August, at which the dentist confirmed no problems. The carer's note for that day records John up and dressed, had meds and breakfast by Dad. Clothes changed and shaved as he was going to the dentist. Dad said one carer to go with John and the other to stay and do the ironing and computer work. Away for 8:45, ironing done and most of the computer work done. John home for 10:30. Red gum at top right, wisdom tooth that might give some discomfort. Dentist couldn't see anything else. So the allegation that he wasn't getting dental care is manifestly false, but still in the system. There's a letter from Dina Scott, Self-Directed Support Coordinator, Perth and Kinross Council, 3rd September 2014. To Mrs. B. Wilson, I'm writing in regards to my request for information you hold on the personal assistants who were employed by your client, Mr. John Shields. As discussed in our telephone calls, this information forms part of an ongoing adult protection investigation, and as such is required as a matter of urgency. Therefore, can you please email me a list of the personal assistants? So, Perth and Kinross Council, after you've been arrested and charged, are now doing some investigation. They're digging. Okay? They're either digging for the truth or they're digging for dirt. We will see. So one of the previous assistants was Ellen Houston. She'd worked for you and looking after John for 5 years. This is what she said of the contact. Quote, earlier this year I received a phone call from social services asking if they could come and see me. I agreed, and when they visited, they said it was just to ask a few questions about John Sr. as his guardianship was coming up for renewal. I point out the guardianship renewal was due in 2029, so they're already lying to this woman, right, to deceive her, to try and get dirt. That's not good. Thou shalt not be a false witness. But the lies didn't work, so she continues. Then to my horror, I was told by another carer that John Sr. was being investigated for allegedly assaulting John Jr. I did not appreciate being lied to by the social workers. And the real reason behind them visiting my house, as it transpired, that they were there to ask me if I'd ever seen John Sr. hit his son. I said absolutely not and was horrified at the very thought of it. And at this point they more or less got up and left and were not interested in anything else I had to say. I contacted social services to complain about this and was advised that they would look into it. Despite repeated phone calls to inquire what was done, I have had no response. So it's quite clear from that statement that there was no investigation. What there was digging for dirt, and they lost interest if there was no dirt. And they certainly weren't about to listen to anything positive about you from someone who had worked with you and John for 5 years and should have been a key witness as to your conduct. I simply point out at this point that this does not show an organisation operating in good faith. This shows an organisation fitting people up.
Well, see, this was a witch hunt. That's what this became, was to get dirt. Now, Ellen became a witness for me in the court proceedings, the criminal case, as I said. So she was named, gave statements, and she went up and she defended me. And the fact was that the dirt that they were going out their way to get this dirt on me. And Ellen knew me and she knew I would never hurt John. She knew that. And I'll tell you something, if I did, she would have been the first person that would have went to the police if I'd have done anything to my son.
So this now brings us to 11th September, Perth and Kinross Council application for guardianship order under the Adults with Incapacity Act. Perth and Kinross Council craved the court to replace John Shields Sr., the welfare guardian, with powers relating to the personal welfare of John Jr. with the Chief Social Work Officer. So they've got an interim, but they're trying to make this permanent now. A couple of things that are worth noting from this. They stated the welfare guardian is the adult's father. His appointment is most recently renewed for a period of 20 years on the 11th September 2029. 28th of August, Police Scotland charged the welfare guardian with 3 counts of assault. The assaults were witnessed by 2 personal assistants employed by the welfare guardian under the direct payment scheme. The welfare guardian was released on police bail with the undertaking to appear at Perth Sheriff Court on 16 September. Police bail conditions inter alia prohibit the welfare guardian from having any contact with the adult. The welfare guardian agreed to the adult going to reside with his mother. That would be a lie to the court, wouldn't it not?
Yeah.
Right, okay, so we're now, Perth and Ross Council are now misleading the court in writing, possibly unwise. The welfare guardian agreed to the adult going to reside with his mother, Mrs. Capson McJimsey, on a temporary basis. Police Scotland are currently investigating allegations that the welfare guardian has ill-treated or willfully neglected the adult, an offence in terms of Section 83 of the Act. Okay, so sometimes in the paperwork it's your agreement that's seen your son leave, other times it's the bail conditions. It flips. It's never consistent.
You've got to remember when the police were going to, they're trying to get me for neglect, they're trying to get me in whatever they can. They go to a doctor, gives them nothing. Everybody that they attended to get dirt on me, they get nothing. So what exactly was the investigation that took place? What investigation did Police Scotland actually do?
Well, it didn't go well.
No, it didn't.
And most of it happened in the weekend. I mean, you have to say, they moved quickly on the weekend where they organised all of this, and then were down with a failed application for removal order. I mean, if Police Scotland were that fast, Nicola Sturgeon would be in serious trouble. Operation Branch Form would have finished long ago. So they then say there was a previous allegation that the welfare guardian assaulted the adult in early 2009, but the police investigation found no evidence to substantiate the allegation. Actually, the note on their file, social work file, says that the police said that the accusation was malicious from a carer. Yeah. So that is quite misleading of the court as well. I wouldn't have thought the court would have been very happy with that. There's also an ongoing lower level. There are also been ongoing lower level concerns about the welfare guardian for a number of years, including the welfare guardian failing to ensure prompt dental treatment for the adult when the carers reported he appeared to be in pain, failing to make an appointment with a dietary clinic, resulting in the adult being discharged from that service, ignoring carers' suggestions about local groups for the adult, which would increase the adult's social activity, which they believed he would enjoy, an intimidating attitude towards personal assistance, limited engagement with professionals involved in the adult's care, including a refusal to engage with some social work staff, and making demands about which individuals he would engage with. Comments. 1. I've seen their reports on you. Their reports on you, including in March that year, were glowing. Mm-hmm. There was no ongoing lower level concerns about the welfare guardian for a number of years. That's a lie.
But that's what the authorities do. That's what the local authority do.
This is Perth and Kinross going to the court. Right? That's one page. There's at least 2, if not 3 lies on that page. Yeah. Right? So there were no ongoing concerns for a number of years. This is the nonsense and chit-chat that's been assembled in the last month or two, right, by the carers. And it's all about nothing, right? Or we think the carers think that the adult should undertake certain activities. Well, it's not up to them, it's up to you. You're the welfare guardian. Right? You've got to risk assess everything. You've decided yes or you've decided no. We've already accepted. They've reported that John had a wonderful life and was hardly ever in. Right? So that is not neglect. That's having a difference of opinion from the people you employ. That is not neglect. That should not have been there. It's reprehensible. Statement by Dr. Andrew Buist, taken by PC and Wilson. John has been registered with us since 2002. From birth, John has a genetic abnormality of the brain, which has caused severe learning difficulties and epilepsy. He takes 2 medications for his epilepsy. His father, John Stewart Shields, has had welfare guardianship of him since 2011. It says, but it's actually been 2003. John doesn't attend the practice very often, and when he does, it's for minor ailments. From his notes, I can see he's not attended A&E, nor the practice for any injury. There have been no unexplained injuries brought to the attention of the health service. I'm not aware of any concerns regarding his health apart from his weight. I have been asked by Police Scotland if John William Shields has a higher pain threshold than the average person. I am not aware that this is the case. Odd statement. Now, so again, they're digging and they're finding nothing. But the decision's already made. The decision was made before the investigation.
Right. Strange thing about the statement about Ewan Wilson was the day that he went out to visit Dr. Buist, myself and Janice had the misfortune of meeting him outside Sainsbury's, and he came walking out and I said, "Oh, what are you doing here?" He said, "I've just been along interviewing your doctor." And I says, "What for?" He said, "I had to take a statement from him." So I went like that, out the blue he starts, he says he wants to speak to me off the record. If you've ever heard the statement of off the record, it means we'll talk but it'll not be recorded. So I says, "Okay, what is it you want to say?" And he says, right out the blue, he came out and says to me and Janice, he says, "I didn't want to arrest you." So I went like, "What?" And he says, "I didn't want to arrest you." I said, "Well, what'd you arrest me for then?" And he went like, he says, "Because he had orders from above." I went like, "What do you mean you had orders from above?" "Above where?" He says, "Look, I come back from work on the 26th of August, 2 days before I had to arrest you." He says, "And here's your file lying in my desk." So I looked at the file and it stated, about the allegations that you're meant to assaulted my son. Your son, sorry. And I went like that. I phoned up the stairs to my boss and says, "Why am I investigating this?" He says, "Nothing's happening here. It's no dangerous. It's no serious." And he went like, "My job is to go after paedophiles, bad men." He says, "And you don't come into that category." So I went like, I says, "Well, who ordered you to get me?" He went like, he says, when I phoned up the stair to my boss, his words to me were, "We were ordered to get you done." And I says, "Where did the order come from?" "Perth and Kinross Council." They had given strict instructions to Police Scotland, at all means, get that man done. It didn't matter. I was flabbergasted. I'm shocked. I'm going like, "You what?" So who would be powerful enough to give an order to get me done for something that I never took part in? And he says, "Look, I don't know what to say." He says, what I've just said to you there just now is, I really didn't want to arrest you.
Okay. So when we talk about multi-agency conspiracy, we mean it, because that's showing Perth and Kinross Council instructing Police Scotland to operate against the best judgment of the Police Scotland officers
That's
involved.
right, yeah.
That seems pretty corrupt to me. I've got here a whole lot of things where you made complaints about the conduct of Perth and Kinross Council, back to Perth and Kinross Council. For reasons of brevity, we won't go into it. I had thought we might do it as light relief, because it's a fairly heavy subject today, and frankly their attempts to justify themselves are quite comic. But it's sufficient to say that it was good that you did this, because it put in writing your concerns about them. But if anyone's ever thought of complaining to a local authority about the local authority's conduct, that's fine, as long as you don't expect there to be anything positive come out of it. It was any wafer thin excuse would do.
Yeah.
This takes us on to October 2014. As an attendance note from Jamie Baxter regarding the guardianship case. He's appearing on behalf of Mr. Shields, explaining that Mr. Shields did not accept the allegations made in the writ and was opposing the application. The agents of the council and Mr. Shields' former wife and daughter thereafter intimated that the matter required to proceed to a hearing, and indeed it would be their position that Mr. Shields should be removed as welfare guardian, and in due course Miss McJimsey and Jennifer Shields should be appointed as joint guardians. In the meantime, however, the Chief Social Work Officer of Perth and Kinross Council should remain the nominated welfare guardian. After hearing all the parties and the brief backgrounds of proceedings, Sheriff Fowlis, same sheriff who threw out the allegations initially, fixed a proof hearing to take place on the 19th of February 2015 at 10 a.m. And a pre-proof hearing for the 23rd of January.
Excuse me, David, but you would think a judge who, 14, 16, 17 days prior, 22 days prior to that, is involved in a court proceeding, refusing access for social work to take my son away. And here he is sitting on the same thing again, only this time it's under the guardianship order, and he's agreeing. No, well, he's not really disagreeing. What he's doing there, he can't stop the process.
But what he's saying is there has to be a process. I think the initial approach was one of, we want you removed as guardian summarily, and he was saying, no, we want a proof. So he's asking them to prove the case.
Right.
So we now come to October, and at long last we get the actual police record of the statement by Ashley, the personal carer, which is a piece of work. So she writes, this is her police statement. I'm currently employed by Perth and Kinross Council as a personal assistant. I've worked for them for just over 3 years. That is false.
She did, yeah.
She worked for you.
No, the council, no.
I'm currently assigned to care for John Shields. That is false, because she resigned from that position the day after the day when the Perth and Kinross Council went to court on her testimony, and she hasn't worked in that position since. So her statement started off with two statements that are false. And apparently she doesn't even understand who her employer was.
Yeah.
That's not a great start. So the police note continues. She says, I work with John, should be worked, but I work with John 3 days a week during 12-hour shifts. We basically assist John with day-to-day living. John's father has always come across as aggressive and intimidating to me and other care workers. Not all of them. I'm also concerned about a number of incidents that happened at John's house when I've been working. Both John Shields Senior and Janice are responsible for verbally abusing John. They both call him names on a regular basis and shout at him. And this happens even in the presence of me and other carers. So again, there's this character assassination, you're a bad man. But only from these two carers. Nobody else in the entire spectrum said anything about this. And then we go through on Friday past. She means August. I was working at John's house, me and Debbie, and we were in John's bedroom with him, and his dad came through with a pair of jeans and told him to try them on. His dad knelt down in front of John and put jeans on John. Young John was pulling at the waistband, basically indicating he didn't want them on. His dad was angry at John. I think he was angry because he had bought John the jeans for his birthday. John's dad pushed John's hand away and said, "What are you doing?" bold caps. And then John's dad pushed him in the stomach and John landed on his two-seater. So this is the pushing onto the sofa allegation, right? And why Police Scotland are even entertaining this as assault?
It's shocking.
It's bizarre,
it's shocking.
right? Because they simply should say, "No, we're not doing that."
So you've got to remember, like, I'm meant to have pushed him onto a couch. He didn't hurt himself. There was no pain. There was no...
Well,
there was nothing.
Wait till you get to the second
No.
statement on that subject, though. On Friday, 25th July, after returning home to John's house after being away on holiday, John never got out of, but we were away on holiday, to Seaton Sands. With him, another incident happens. It was around 7:45 at night, and we were in John's bedroom. John's dad wanted John to go in the shower. John was sitting in his chair. John didn't get up to go into the shower as quick as his dad wanted. So his dad walked over to John and slapped him 4 times in his stomach. The slaps were hard enough for me and Debbie to hear. John didn't show any expression of pain, but he wouldn't in front of his dad because he was scared of his dad. Me and Debbie didn't say anything to John's father and left the room when his dad put him in the shower as our shift had finished. Didn't say anything to anybody, actually, dear. Also on 4th of August, another incident occurred, which I'm concerned about. Again, I was in John's room with him and Debbie and his dad. John had been expressing pain when he'd been brushing his teeth on the upper right side. His dad had been saying that there was nothing wrong with his teeth, and this goes on and describes the toothbrushing, the alleged assault with a toothbrush. So that's kind of that. She then says, because of all these incidents, we felt we had to mention what happened to John's mother, Catherine McJimsey. We informed John's mother and Catherine on Friday past when we met at Perth for John's handover. So there was chit-chat. 24th of October 2014, statement by Debbie, the personal carer. Statement taken by PC Ryan Williams. I have worked as a personal assistant with John Shields for 3 years. I am employed through Perthshire Council. Not only does she get the wrong employer, she gets the wrong name of the wrong employer. She means Perth and Kinross. I work in a team of 3 people. There should always be 2 people at a time looking after John, but sometimes there was only 1. I work 3 days a week doing 12-hour shifts. And John is called a unique child. When John was born, the chromosomes snapped and reattached the wrong way. Okay. Closer than some others have managed.
Yeah.
Right?
She's a clinical psychologist, as well as well.
And this left him with learning difficulties. He's non-verbal but can understand everything being said to him. He communicates through his eyes and by pointing and using hand gestures. I know John really well, so I've worked with him for a long time. I feel we've a really good bond. Yes, dear. Every morning when we go, he's sitting up in bed and he sees us and wants up and out. It's almost like he wants to escape. So you see, this is another thing, right? This happens over and over again. Everything is viewed through this negative lens. He's not excited that he's got a full day ahead. No, it's almost like he wants to escape. You know, you call them names. I was describing this to Leslie earlier on. I said, well, you know, she calls me Pumpkin. If I wanted to say that that's a comment about my weight, and she calls me this all the time, and I'm beside myself with grief, and she keeps teasing me about my weight because she calls me Pumpkin, that would be a complete lie, because it's a funny term of endearment. You can paint anything as evil if you have a mind to do so. The police are meant to be looking at a higher standard of evidence than that.
Yeah.
But they didn't.
See, you've got to remember, she was there for 3 years. Is she trying to say, like, every morning that my son got up, he didn't want to be with me? So for 3 years this has been through their heads, that John was reacting towards me, that he didn't want to be with me. That's one hell of a statement to give when you're supposed to report issues to people.
So John's dad doesn't work and is in the house. So you're a lie about it, apparently. Doesn't work and is in the house most of the time when we're there. His dad is very aggressive to us, his tone and mannerisms. He talks to us like dirt. We are scared to talk to him sometimes. He tells us to hoover, iron and other things which we shouldn't be doing. They were employed to do the hoovering, ironing
For John.
John, yeah. Well, okay, so we ended up doing these things and we feel intimidated by him. So, you know.
Why would you work with somebody
for 3 years?
For 3 years, and that's what they're like every day.
And never a word.
Never a word.
Not even that, you know, our bosses mean to us. Never a word.
No to the police, no to social workers. But
Palmas, anybody.
I'll go to my daughter and my ex-wife and I'll tell them. Why no go, as they know that they're meant to do, why don't they go to the authorities that they're meant to do? They didn't go to the authorities. They went through my ex-wife and my daughter. You can see the plan. You can see how they put all this together.
I think it's called being coached.
Yeah.
He will take a newspaper and hit John over the head with them, pretending it's in a playful way, but it's not. John just puts on a false smile on his face and puts his head down. Is John capable of putting on a false smile?
I don't think so, no. He's learning this. He wouldn't know what that means.
It happens almost every third day. John's dad doesn't
Every
really
third day?
Every third day. Have any patience either. I've seen him force John onto the toilet and tell him to do the toilet when he doesn't need before they go out. So again, this just seems to be the criminalising of appropriate and caring parenting.
Yeah.
When you're out with John, presumably needing a bowel movement is a bit of a palaver at best, and I would imagine you're quite keen that he goes before he leaves.
Yeah,
the
well,
house.
that's what practice was.
Yeah.
That you see, we do the toilet first
Yeah.
before he goes out. Now that's been going since he was a wee boy.
John's dad has given a lot of money for the care of John, but he abuses this. The money he spends on John is very limited, from clothes to food to the small TV in his room. I feel so sorry for him. So this is someone who doesn't have any view over the money. The money situation is thoroughly checked every year and audited. And
Every month.
Every month.
Every month
Right.
it's audited, yeah.
And there isn't a problem, so that's nonsense as well. Also a suggestion that you basically don't want John about. There's all sorts of mud being thrown. It's not anything substantial. It's just mud. Then there's the claim that John wasn't getting a good diet because, and this is because he wasn't eating the same food as you, but he was on a special diet because he had a weight problem. So, you know, on it goes, is stuff we've seen over and over again. She then says, at least every second week when we go to the house on a Monday morning, John will have bruises. There's no information where, what size, nothing. Nothing was ever recorded in any of the daily logs that they fill in. The doctor never reported any bruises. They never reported any bruises. But she's saying every other week for 3 years, presumably, she's finding John with unexplained bruising that no one else has seen. That seems A, unlikely, and B, well, why didn't she report it?
Well, to be honest with you, she did report when John was down at his mum's that he was coming home and he had bruisings.
Oh, so it's not every second week, it's every third week.
But that's when he's away at his mum's.
Oh, of course, right, okay. So the person that they're trying to get him to go to, he's got unexplained bruising when he's been there.
One of them was pretty big at the time, and it was supposed to be that when he'd walked in his room, and he'd went to walk out the room and he caught it on the side of a table or a chest or drawer or something like that. And it was a fair bruise, but there was never any issues about it because as far as I was concerned, you know, there was no skullduggery going on here, and it was being recorded. But every 3 weeks, no, that never ever happened. And it doesn't paint a good picture of my ex-wife, who's meant to be watching him every 3 weeks.
Yeah. And
here's a carer saying, well, he's got bruises every Monday. But that's the Monday that he comes back.
That's the one that comes back. Okay.
From the mother.
That's interesting. Okay. So she then goes over the toothbrushing incident again, which was eventually dropped because you provided it a statement that was best practice, and from a professional, and had to accept that, so that one went away. But there's a long piece about this. She said John looked really uncomfortable about it. It upset me and Ashley. This shouldn't be happening. John was supposed to attend PRI in June to be put to sleep. Not a great turn of phrase, to be put to sleep in order to get his teeth checked, as he doesn't like people looking in his mouth, but his dad had cancelled this. So because you didn't think that a general anaesthetic was necessary, which as welfare guardian was your call to make, that's been presented as neglectful or uncaring. Everything's been presented in this way. In my opinion, John's dad doesn't want any professional people in John's life. John should have a dietitian, a speech and language therapist, and a nutritionist at least.
They had all them in the health centre anyway. They were all looking after him anyway.
So that's wrong. He could also attend college if his dad would let him. Now, we found a note on that, the previous carer. We were able to enrol John into Perth College on a life skills course. Unfortunately, this did not suit John Jr. as there were too many distractions. So you had actually tried that.
Between that, he would fall asleep when he was in the place.
Okay.
So I think it was Ellen Houston at the time had decided to make that decision, saying no point taking him into Perth College. He just keeps falling asleep.
Okay, right. So the next one's strange. So this is, as I say, this is the statement of Debbie the carer, 25th October 2014, to the police. She describes the following. 10:30, Friday the 22nd August 2014. I was in the bedroom with John. His dad told him to get him a newspaper. As John's dad got his money out and went to give him the money, John flinched when his dad's hand came over. He looked scared. His dad shouted aggressively to him, "What? I'm only giving you the effing money to get papers," in caps in the statement. This again upset me, as it's not right. I don't like him being treated in this way. So what she's suggesting is that you give John Jr. money and send him down the shops to get you a newspaper. How many times did you do that?
Oh, quite a few.
Yeah.
As I say, because he was accompanied by a carer to go.
Oh, with a carer, right?
Yeah,
okay.
He's with a carer going.
Right, because he couldn't go on his own.
No, he was going down there with them, and they were taking for a walk. Pick a paper up for me. So he would give him the money for John to go up and learn how to start paying for things. And that is what they got the money for, was to buy a newspaper. So they were going down there with John near enough every day. If John was going out for a walk and I never got a paper, even the 3 days that they were working, and there was two, and you got to remember there's two of them going down with John to get a newspaper.
Okay.
So I don't know what her complaint is here. It's unbelievable where they're getting this info.
That never appeared in anything.
No,
right?
That's something I'd never really
but
heard
again,
about.
It's all this sort of innuendo. So she then writes, about 13:30 hours on the same date. It's the same day, so you're a bad man. His dad had bought jeans for John's birthday. So this one did make the allegation. In fact, this was you convicted
This is
of
the
this.
allegation.
John had jeans on and was standing in front of a sofa in his bedroom. His dad was on his knees in front of him checking the length. John didn't want the jeans on and was trying to get them off, but his dad had been forcing him to keep them on. When his dad just pushed John really hard in the stomach, forcing him to go flying backwards onto the sofa. You see, everything's embellished, right? Not sit down, son. Flying backwards, all made dramatic. Both I and Ashley were in the room at the time. His dad just walked out of the room. We were upset about this again, and it's not right. It's all about her emotions. Very strange statements. Another thing I recalled, his dad forces him in a treadmill for 25 minutes. So, you know, your work to get him to keep his weight down is forcing him in a treadmill. Everything good is looked at through this lens of evil. And she completes with the following unbelievable statement. I feel John would come on leaps and bounds if he lived independently. I feel he's suffered enough. I feel it's his time to enjoy what life he has left. This is emotional verbiage, dross, right? None of this. John can't live independently.
No.
He would come on leaps and bounds if he lived independently. He wouldn't last a week.
That's it. I think what she's meaning is independently with carers looking after him. I think that's it. No, but the carers that she's talking about is the mother and the daughter who live in Glasgow.
That's not independently. That's not what she says. I feel he's suffered enough, and I feel it's his time to enjoy what life he has left. As though he's on the way.
Drop dead the following day.
It's just a very strange statement. Okay, so we're now on the 12th of November 2014. Anne Prentice, John Jr.'s social worker to John Shields. So they're organising supervised contact. Further to this, she says, I wish to inform you I met with John recently. He's looking well and is attending some activities locally, which I'm told he's enjoying. I handed over John's spectacles. Also, John has been to the dental hospital in Glasgow, and it transpires that John has gum disease, gingivitis in his upper right tooth. The dentist couldn't see any significant hole, any other issues in the tooth. Gingivitis, early stages gingivitis, you might start to have gum inflammation a few days after neglecting or not properly following oral hygiene. However, the signs of generalised gingivitis become more noticeable within 2 to 3 weeks. This is 2.5 months after they took him for a year. So one of the charges is how you brushed his teeth. 2.5 months after they've seized him, abducted him, he's now in the dental hospital because of problems with his teeth. And yet, at no point does any of this cause them to reconsider their actions. So we're now a note on the 20th of January 2015, statement by Maureen Phillips of Palmas, yes, taken by your solicitor. I've been involved in Palmas for over 10 years. John Shields has been involved with Palmas since prior to my involvement in this area, and I'm aware he was previously involved with Palmas in South Lanarkshire. I've been involved in providing the family with supports, service, and have organised workshops for the family and their carers and have assisted in young John's care. I've attended at the home address on numerous occasions to review matters and see what support we can provide with the family. I think I've attended their home on perhaps 3 occasions in the last 12 months. Maureen Phillips continues, I have had accordingly a considerable involvement with this family for 10 years, and I can state that at no stage have I ever had concerns about young John's treatment by the family. The whole time I have known young John, I've had no doubt that his family, and his father in particular, have always acted in his best interests. John Shields Sr. is dedicated to his son. I have not found John Shields Sr. to be difficult. I consider he's passionate about his son. John has taken all steps he can to understand his son's problems and try to provide a better quality of life for him. I know over the past 10 years John's had a number of difficulties with local authority in obtaining the appropriate package for his son. I'm aware he did everything he could to obtain that. At no stage, however, did I think he was not acting in his son's best interests. Indeed, I know he felt he had to do everything he could as his son was not able to properly communicate on his own behalf. I'm aware that a number of complaints have been recently made by the carers at John's home regarding the way John has been looking after young John, and indeed understand it's claimed he assaulted him on 3 recent occasions. I'm very surprised to hear this. I'm particularly concerned that these 3 incidents were not reported at the time they were alleged to have been committed, but only reported by John Shields' ex-wife a month or so after the events. I do feel if these incidents were as serious as have been made out by the carers, they would have done something about it right away. There is a procedure that should be followed when such incidents occur, and not only should such incidents be logged, but depending on the nature thereof, a formal report should be made. The carers were well aware of these procedures and should have followed, and if there were any doubts, could have contacted either the social work department directly or have spoken with myself. It was only the previous year I attended at the Shields family home regarding a complaint that had been made against another carer for having struck John and generally behaved inappropriately. At the time I was too late to do anything about the incident that was complained about, but it's made perfectly clear to all of the carers that it was their priority to ensure the welfare of the vulnerable adult. I'm pretty sure that the carers that remained attended workshops we organised regarding these issues. So it's absolutely clear that she thinks you're doing marvellously, and this is 10 years experience. She continues, I note that young John can be difficult to look after as he is such a big chap and can be difficult at times if he does not get his own way. I have, however, never seen John Shields act inappropriately towards his son, and I've only ever seen him being passionate about doing things for his son. Mr. Shields has ensured that his son has a full and active life and takes him all over the country to watch football matches. I know John was quite frustrated that there were no classes and groups organised which catered for young John, as he was so keen to ensure that he was as independent as possible. John was always looking for things to do for his son. His son regularly went on holidays, not only with the family but also with the carers. I always felt he was very well looked after and find it extremely difficult to believe that John would have assaulted his son at any time.
And that's an expert.
It's an expert with a lot of experience, 10 years of experience.
But the social, the local authority totally ignored her.
Yes.
They never even took her and questioned her. They never went near her, never
Really?
They never interviewed her or nothing. It doesn't matter what Maureen said. Maureen's in a situation where this is the local authorities taking over again. She works for PAMIS. PAMIS are funded by local authorities. They get money from the local authorities. I remember Maureen, she actually said she had to watch sometimes what she had to say, because that's who their money came from. They get money through charity, they get money through donations, but the bulk of their money comes from the local authorities. As I said, and here was Maureen helping me. She knew what was going on in the house. She knew the problems I was having. I says, and she stepped in and she knew exactly what had to be done.
So we've got a note here, 23rd of January 2015, attendance note by Jamie Baxter appearing on your behalf, pre-proof hearing with a hearing fixed for the 19th of February. So this is the civil case regarding guardianship. The Sheriff noted the trial date was set for 27th of January. Sheriff Tate considered that the outcome of the trial may well go a long way to resolving these proceedings. Confirming that it was accepted, the Sheriff considered there was no advantage in proceeding with the hearing on the 19th of February, considering it was appropriate to discharge the diet and make the 19th of February a notional diet at the time the court would be advised of the outcome of the criminal proceedings and the consequences of those. So although Sheriff Fowlis had said that Perth and Kinross Council would have to go to proof and make their case, when the proof came up, it wasn't him, it was a different sheriff, Sheriff Tate, who said, well, we'll just let the criminal case run and that will basically decide the outcome of the guardianship. Right, so the fix is very much in. And then the 3rd of March 2015, there's a letter from Stephen McGowan, Procurator Fiscal. Stephen McGowan is someone we know from the Holly Gregg and Robert Green case, and it's very surprising to see his name crop up again. And he's from Major Crimes and Fatalities Investigation, so it's also very strange that he's writing to you at all. We don't know why they picked him, but he's talking about the criminal diet was discharged at the hearings on the 27th of January 2015, the 25th of February 2015, so they keep putting the trial back, eventually commencing the 24th of March. Now, we've tried many times to obtain the court transcript of that criminal trial, but we've never got that.
No, it's no there, they don't have it.
The witnesses were called for the prosecution were the personal carers, Debbie, Donna and Ashley, Ewan Wilson, Maureen Phillips were the witnesses that were called. Jamie Baxter, we've taken all of this to another lawyer who's reviewed this, what you might call a hotshot criminal lawyer. And his view was, well, what you've suffered from here is very low quality representation typical of legal aid work. And what he said he would have done at this point in the trial is say there is no case to answer. Because there's no criminal activity, there's no mens rea, there's no case to answer. Unfortunately, Jamie Baxter did not put that to the judge. It went to a decision. Is there anything else you'd like to describe about the court case before we go to the verdict?
To be honest with you, the court case was a farce. Even Ewan Wilson, police officer, arrested me, took me in, and then he was called as a witness against me. He came into court, stood in front of the judge. Judge says, "Who are you?" And he says, "He was the police officer who arrested me." And the next minute he says, "Okay, that's fine, away you go." And I remember meeting Ewan Wilson outside the court, and he says, "That's the quickest I've been ever in and out of court." I says, I was wondering why, because they never asked you one question. They just asked you to point out who I was. And that's all I done. Now Ashley, Deborah and Donna, every one of them stood up in my court of law and they made allegations against me. And not once was my lawyer asked for any proof that this had happened. There was nothing.
So you had low quality representation on legal aid. He didn't suggest that there was no case to answer, which he should have done. You were found guilty on 2 counts of assault. The assault with a toothbrush charge, which should have been the basis to start the whole thing off, was dropped because you had expert testimony that this constituted best practice in caring for a disabled adult. And your lawyer advised you that there was no basis to appeal the verdict in law. Now, again, we've taken advice on this, and the advice has been that the lack of mens rea was never challenged in court. There was no motion to dismiss on no case to answer, and the lack of mens rea would certainly be a reason to challenge and to appeal, because the appeal would be worded something like, it seems unlikely that the judge had sufficient reason to conclude that there was mens rea. Mens rea is guilty mind, and if you don't mean any harm, you've not committed the crime. Certainly an assault, it requires mens rea. Most crimes do. So that was the position. And you then got a letter from Jamie Baxter. As you're aware, after the court heard all the evidence of these proceedings and submissions from the Crown on your behalf, the Sheriff adjourned the trial to consider matters. After recalling proceedings, the Sheriff intimated, having reviewed the evidence, he was satisfied beyond reasonable doubt that charges 1 and 3 of the complaint had been proved, and in particular in this regard accepted the evidence of Deborah and Ashley as being reliable and credible. Interesting. Whereas he did not accept the evidence led on your behalf as being reliable and credible. You were accordingly found guilty of these charges, as the Sheriff has a doubt about the evidence that had been led in support of the second charge. You were found not guilty. Odd that he would have a doubt on one evidence, but it's the same people. So the people who were credible and reliable for 2 charges, he didn't believe on the third. That seems, again, a very inconsistent. They were either reasonable or not. He doesn't seem to have dismissed the third charge because of the expert advice. He seems to have dismissed it because he didn't believe the carers, which is very strange. As the Sheriff was in doubt regarding the evidence that was led in support of the second charge, you were found not guilty of that charge. In view of the nature of these charges and the circumstances of the offences, the Sheriff considered it appropriate to defer sentence to 16th of June at 10 a.m. from the purpose of obtaining criminal justice background reports. Please note this date carefully as you're required to attend. And he writes, as you are aware, following the conclusion of the trial, we did discuss the possibility of appealing the convictions. As explained, as the Sheriff made clear, he found the Crown witnesses credible and reliable, and sufficient evidence had been laid before the court in respect of charges 1 and 3. There is no basis in law to appeal these convictions. There is a basis in law. That's just him being a rubbish lawyer, I suspect.
He's actually denied that now, that he even said that to me.
Well, it's in writing. He can't deny it. So on the 8th of June 2015, Criminal Justice Social Work Report to the court to aid sentencing came up. Interview with Mr. Shields at the Criminal Justice Service Office, 1st of June 2015. Discussion also took place with Gillian Morrison. Gillian gets about. And reference was made to the police report prepared at the time of the offences. Context with reference to the police report completed at the time of the original complaints were made. I understand that 2 victims' carers reported the incidents, stating they were very concerned about Mr. Shields' treatment of his son. They added that, in their opinion, he was intimidating and aggressive. I note that they added that they themselves were frightened of Mr. Shields. I further note from the departmental records that Mr. Shields denied the offence but admitted to chastising his son by slapping him lightly in the body in order to encourage him to go into the shower. That's odd.
No, that's a total...
Did you ever do any such thing?
Oh.
Okay, so there again, this is from Perth and Kinross Council, Gillian Morrison. Again, she's stating another thing to the court that isn't true.
No, that's true. That's what she done.
Right? She said, you denied the offence completely, stressing you would never harm his son. Right? Even your lawyer, Jamie Baxter, made a marginal note and said John didn't admit to chastising his son. So she said, sorry, let me just read that again, because lying to the court is a serious matter. I note from our departmental records that Mr. Shields denied the offence, but admitted to chastising his son by slapping him lightly on the body in order to encourage him to go into the shower. So their departmental records are fraudulent.
Yeah.
And they're putting fraudulent records before the court at your sentencing,
Yeah.
still trying to back up that there's something there. Right? That shows a weakness, that they know they don't have a case. Even after the conviction, they're still lying to bolster it.
Yeah, we
That's
noticed
very
that.
odd. The question, what is the individual's attitude and insight into the offence? Mr. Shields does not accept that the behaviour towards his son was unacceptable on any occasion. He is keen to point out that he was the main carer from 2002. It's actually 1999, that's factually wrong as well, but hey, it's only 3 years out. That's, for these boys, that's close enough for government work. When he took his son out of the care of the Church of Scotland establishment, he gave up work and looked after him on a full-time basis. He tells me that he was unaware that his son had been put into care at an earlier date by his ex-wife, and as soon as he found out, he endeavoured to bring him up himself. They say, what is the level of recognition by the offender of the impact of consequences of his offences on the victim or community? Mr. Shields denies that any harm has been caused either to his son or to others who care for him. It would seem that he feels that he's been wrongly accused and the victim on this occasion, and he feels compelled to clear his name of any culpability. He reports that he will do so by taking a polygraph, refuting any suggestion that this may provide inaccurate recordings. Now, polygraph is used extensively. If you go onto the UK government website, they are using polygraphs to assess offenders all the time. So they're trying to dismiss the polygraph, but that won't fly. What happened when you took a polygraph?
I got a chap who stays down in Kent, and I can't remember his name, but he's got a company, and he personally does polygraph tests for the Metropolitan Police. He also does polygraph tests for Interpol, and he's been involved in big cases where he's went and done polygraph tests on people. So I read about him and I decided, okay, I'm going to give him a phone. So I phoned him up, and he was a nice chap, and I told him my case. I says, would you be willing to do a polygraph test on myself? So he says, yeah. He says, what you do is send me the basis of your case, and I'll look at it and I'll find questions that I'll ask you about. You'll not know what they are. He says, so we'll meet. I'll put you through the polygraph test, but I will pick the questions and I'll ask you the questions. So I said, sounds okay to me. I've got nothing to hide anyway. So phoned them and we got it arranged, and I rented a room in Edinburgh at one of the hotels, and he met me. And I went into the room, and here was all this equipment all sitting out for the polygraph test, and I tell you, it's scary when you see what you're doing. And he says, I'm going to sit you down in this. You're sitting on a seat, and there's a wee sensor, and you sit on this thing, and then he puts all these wee clips and wires you up, and he does your finger and that, and he says, okay, I'm going to start doing the questions. And he started to ask me the questions. Once I sat there, it was fine. It was okay. As I say, she had nothing to hide anyway. And anyway, he done the testing, and he asked me the 4 questions, like, did I assault my son? Did I do this? Did I do that? And that's what it was about, was to find out whether I was lying or not. And anyway, he says, okay, that's the test done. I said, thanks very much. We went and had a wee cup of tea, and he went like that. He says, I'll send you the results. And then I got the report. It was a couple of weeks later, and it came through, and you got a folder with everything about what the testing and what you were showing, the results and all that. And it actually came back, I was 99.98% innocent. of the four, well, I think that was four questions that he put over to me concerning what I was supposedly done to John. And they went like that, he says, you not to worry about it.
So the sentencing report concludes seriousness. Harm has been caused in the current instance may be assumed to be at least significant. Right? They're having to assume the level of harm because there wasn't a mark on John, there was no behavioural problems, there was no nothing. There is actually no evidence of harm. Harm's assumed.
Yeah, it's well, when you go back, David, to what you'd said earlier on, you've got all these agencies that Police Scotland went to visit. They went to them all, everyone where they said there was, you know, like the teeth, the doctors, everything. They went and met these people and talked to them. I've seen the reports, and they had nothing.
Did nothing. No. So the two assaults were committed several weeks apart and were inflicted on Mr. Shields' son, who has severe learning disabilities. Two assaults several weeks apart. Out of, you'd cared for him, well, by this point for 31 years, with at least part-time or full-time. That doesn't seem to even engage brain cells. So Mr. Shields' son has limited comprehension and cannot express himself verbally. As the main carer at the time, Mr. Shields abused the position of trust in a very close relationship, and one from which his son had no means of escape without intervention of another. Conclusion: Mr. Shields is a 57-year-old man who's only come to the attention of the court on one previous occasion.
Driving offence?
A driving offence, right, for a minor and unrelated matter. Nevertheless, the victim was a severely learning disabled son for whom he was welfare guardian, and he broke a position of trust with a vulnerable individual who was not able to move himself from the situation without the intervention of others. There's a gap of several weeks between the offences, indicating that the significant psychological, if not physical, harm caused was sustained over a period of time. There was no evidence, even that's not true. There was no physical harm. There was, at no point has anyone said there was physical harm.
No, never.
Right? So this is, even when the sentence, it doesn't stack up. It was sustained over a period of time rather than being confined to only one occasion. All of the community-based disposals are available to the court today. In view of the circumstances, the court may wish to consider imposing a community order with unpaid work requirement to reflect the serious nature of the offences committed. Right, so the sentence was 100 hours unpaid work, and that's meant to look at the serious nature of the offences committed. What do you make of that?
I find it shocking. I can go back to the fact that I've got a friend who was a lawyer who was involved with me in the early days. His name's Tony Callahan, and I've actually phoned this man and I asked him about, you know, what had happened to me, and he went like that to me. He says to me, "What did you get for your sentence?" I says, "They gave me 100 hours of community service." And he went like that to me. He says to me, "What?" He says, "For serious assaults like they're talking about on a boy, a learning disability adult, and they gave you 100 hours of community services." Aye. He says, "What a load of rubbish." He says, "You know where you should have been?" And I says, "If you'd have committed that?" He says, "Jail." He says, "You should have been sentenced."
Well, I mean, you make a good point, because the sentence and the narrative don't stack up.
No, they don't.
If it was a serious breach of trust and a serious assault on a vulnerable adult, 100 hours of community service,
I would want to be in jail. I would put them in jail.
Doesn't cut it. So, just to finish, I would like to read a letter that we wrote together, signed under your name, but we had cooperated on this, to Stephen McGowan, who's now Deputy Crown Agent Litigation, Crown Office and Procurator Fiscal Service. Dear Mr. McGowan, we have previously met and discussed the case of my son John Shields Jr. You may recall that he's an adult with incapacity, has been profoundly disabled from birth and is unable to speak. Consequently, when I discovered he'd been physically and sexually abused, or raped, at the Mallard Church of Scotland home in Springburn, Glasgow, I considered my duty as a loving father to speak up for him. My actions to highlight his suffering have resulted in my own prosecution by the state in Scotland, that is by the Crown Office and Procurator Fiscal Service, your organisation. The purpose of this prosecution was a singular objective to remove my son from my care and thus silence or at least fatally weaken my advocacy on his behalf. The evidence gathered against me was dismissed as worthless by a judge in a civil court as it did not amount to a risk of significant harm as assessed on the balance of probability. 3 days later, the Crown Office put this same evidence forward as proof of criminal activity by me. I must be entirely clear as to the quality of the evidence your department mustered. It was exactly equivalent to watching a man slap the back of someone who is choking, only to charge him with flogging. The case was coordinated by Perth and Kinross Council Social Work Department. This organisation has admitted that their actions were based neither on statute nor on policy, nor on standard operating procedures. What they did was unprecedented and entirely contrary to their professional duty. It was a sting operation to silence me. I have strong evidence that a senior politician was at the heart of this shameful series of events, as this happened only weeks after he attempted to bribe me to abandon my campaign for my son, and then, when I refused the offer, threatened me and my wife. The attached summary outlines what was done to me. I have detailed files on both my son's abuse and on my own treatment. Now, Mr. McGowan, my understanding is the Crown Office has a duty to prevent vexatious, malicious or malign prosecutions of innocent men. In my case, you have entirely failed in that duty. The result can only be seen as an affront to justice. I cannot get Police Scotland to investigate. After all, they were central to the wrongful prosecution. It is therefore perhaps understandable that they avoid engaging with the issue. Understandable, but nevertheless reprehensible. My question for you is, will you and the Crown Office do your job and assist me in reversing this affront to justice? I look forward to your reply. And what was the reply, John?
None.
Silence was the bold reply from Mr. McGowan. We'll leave that here. The next episode is going to look at the guardianship, and the final one will come to the matter of the politician that was alluded to in that letter. Till then, John Shields, thank you very much.
Thanks again, David.